Well, I'll go ahead and begin because it is 5 o'clock. So welcome everybody to the Thursday, December 15th, Nantucket Conservation Commission kind of special meeting for Sconset Bluff. This meeting is being held entirely remotely with all participants participating via Zoom. Jeff, I don't believe we have a YouTube link tonight, or do we? Okay.
No, this is all on Zoom, but it is being recorded and will be posted up probably some point tomorrow.
Okay, thank you. So everyone truly is participating on the call if they're participating. I ask that all participants please keep your computer or your device muted when you're not speaking so that you're not picked up by the recording and you don't distract our minutes. I also ask that anybody who wishes to speak, please raise your hand in your camera window or virtually and wait until you're called on to speak. If you are a member of the public or representing a project, please state your relationship to the project or your address relative to the project, just so we have that in our record. I believe that is it. So we will begin tonight under public meeting, public comment on items not being heard this evening. Do we have any public comment? RJ?
Thank you, Chair Arisman, RJ Turcott for the Nantucket Land Council. First, I would like to just bring up something from back in August, September, where we were discussing some of the issues that were being had for some of the properties downtown, that their stormwater infrastructure is not up to the task and they're having trouble finding someone to service those things properly. I know that was supposed to be on the October 27th agenda, but I don't believe that it was ever actually addressed.
Thank you, RJ, for that reminder. Jeff, do you have any updates, or maybe we can put it on the agenda for next week?
Yeah, we'll put it on either this one or the next agenda. I'll catch up with Will and we'll put it on the next one where it seems to fit. I think the next agenda is already scheduled to be pretty long from filings, so it may be the first one in January, but we'll get it on there soon.
Thank you. Any other public comment on items not being heard this evening? RJ?
Do you want me to comment on the letter we submitted now, or you want me to wait?
The letter you submitted relative to SBPF?
Correct.
I would say wait until we're discussing it. Thank you, RJ. So if there's no further public comment, we will open the public hearing. We have notice of intent for the Sconset Beach Preservation Fund, 41 through 119 Baxter Road, SE 483598. My eyeballs are telling me correctly. And the intention of tonight's meeting, first and foremost, is to discuss the rehearing limit and whether or not we can proceed with a notice of intent. So first, I want to ask if any commissioners have questions or comments about kind of the process we're going through tonight. Mark Beal, and then I'll go to you, Joe.
Thank you, Ashley. Ashley, I know you've been before the selectmen 2 or 3 times, and I understand was most recently is yesterday. Have there been any reaction, either pro, con, or on hold?
So I was not at their meeting yesterday. I sat through their meeting a week ago, and as far as I'm aware, they have not discussed the issue since I attended their meeting almost 2 weeks ago now, or just over 2 weeks ago, despite the statement that they intended to kind of bring up the issue again last night. Go ahead, Mark.
Then just, I guess, for our records, I'm a little uneasy where there are conflicting legal views here on the repetitive nature of the application, if there is one. I feel uneasy without counsel, just that's my opinion. Thank you.
Thank you, Mark. I agree. I think we have some questions that we will be able to answer tonight, or at least have kind of productive discussion. And then some questions are still of a legal nature that I would be more comfortable having representation for. I don't know that we can put it any more clearly to the select board at this point, but maybe we can discuss ideas on how to better help them to understand the position that we're in and the need for legal counsel. Joe, you had your hand up, and then Linda, I see you.
Yes, I did. My question was going to be, do we have an attorney? And apparently we don't have an attorney. And when I thought about this, I said, why don't I simply make a motion to adjourn?
What?
That's what, I'm glad somebody said what. Because we already have two law firms battling it out. I've read this stuff a couple of times. I don't understand all the legal rigmarole behind all of that. And I'm saying, without legal representation, what are we going to decide here? It's going to be very, very difficult.
So thank you, Joe. I agree there are aspects of this process that we will have difficulty answering without legal counsel. I think we can still have productive discussion, probably about potential material changes to their project. But I agree, having counsel is really important here for us.
I look at it as we're on a super highway headed for the cliff. Both us and the other side would like to take the first exit and sit down and talk about what's going on. But we need some legal representation. And without that, the path is pretty clear. We're going right over the cliff unless somehow or other this gets detoured.
Thank you, Joe. I do understand that perspective. And I think hopefully once commissioners get their initial questions out, we can again have some productive discussion and hopefully bring this back and ask the select board to watch our discussion to hopefully change their perspective. My feeling truly is that with a project of this nature, it's surprising to me that the town actually wouldn't want us to have our own independent counsel, as it gives two looks at this project, two chances for the town government, whether it be the select board or the Concom, to make sure that all T's are crossed and I's are dotted. But the way it has been set up for us currently is skewed so that things are only getting reviewed kind of on the select board side by council. So again, I totally hear your concerns. And I want to make sure.
Actually, both sides are well lawyered up. And we're here like sheep.
Yes, no, I spent an hour in front of the select board trying to put this point across. So thank you, Joe, for stating that.
Yeah, I like those.
Showing them around?
And Linda, your hand was up next, and then Jeff, I'll go to you.
I'm quite familiar with the repeat applications between the ZBA and the planning board. And I was concerned about Dennis Murphy's letter because he left off the rest of that section and he misapplied that section. So I'm more inclined to go with Goldston Stores on this, and I would like to hear from town council. I know from what I heard today, he is reviewing it. Apparently there is a letter out there somewhere. We don't have it, and we should, from our town council. But I don't agree with his letter at all because it's a material change. There's a different applicant involved with the previous applicant. And there's a change in the request for the project itself. So I agree with the points made in Golson Store's letter, because that gave you the entire section and it cited the entire law involved with repeat applications. On top of the fact that we never denied it. The court cases have nothing to do with a denial of an application, which would then, unless they materially changed it, would then preclude them from coming back under our statute for 3 years. That was never done. There was never a denial. There was lack of adherence to the conditions, that's for sure. Just from the sand mitigation itself. But they never got denied. There was no application denied. And for this too, for Murphy's letter to have any validity, there would have had to have been a denial. There wasn't. So I'm kind of perplexed by his letter versus the letter we got from Golson Stores. And I am in favor personally of going ahead and making a finding that we can rehear it or can hear a new application from a new applicant involved with the other applicant with a different scope of the project. And I think we'd be very, very hard pressed not to be smacked down in court if we did not go forward with hearing it, at least giving it a shot. Whether or not we all vote in favor of it is immaterial at this point, but we have a requirement to hear it because they've made an application. So that's how I feel.
Thank you, Linda. And we will, hopefully you'll be able to bring up some of your points again when we discuss, material changes and merits as part of this. And, I agree with what you're saying. We have council review on both sides. I must say the last instance on the commission that I kind of trusted the counsel of an applicant, it actually went to court and was kind of denied and thrown back at the commission. So I am no longer going to take that track and always going to request either our town council's opinion if there's no conflict of interest or an independent counsel's opinion, because I don't want to get stuck like I feel like I did last time I did that. Jeff, your hand's been up for a little while.
Yeah, thank you. I just wanted to add a little bit of context. I know we're talking about the rehearing limit. I think whether or not I think there's going to be some disagreement of whether members of the commission and members of the public agree whether the provision in our bylaw applies or not. There is that secondary standard, and Linda just touched upon it a little bit, but that secondary standard that even if it does apply, is it can be overcome by, findings that there are changes in circumstances or significant material changes to the project that can still allow it to be heard even inside that window. So I think as we kind of go forward, I just wanted to kind of also preface that with obviously, some analysis of whether or not there are those changes is going to be required either way, whether it's determined it applies or it does not, because you're going to have to overcome that standard. But also as we do so, to keep in mind that, we're really focused on those changes and not necessarily the merits of the application. So, not necessarily talking about whether proposed mitigation volumes should be higher or lower, or things, longer or shorter, but really if the concepts provided in the application or, other aspects of it are significantly different enough from the more previous approval, the previous denial for the extension is outside that 3-year time window. So we're really focused on whether it's on that active permit, but I still think the analysis is necessary for those changes.
Thank you, Jeff. Vince, do you have a question?
Thank you, Ashley. Vince from the Vince Murphy Natural Resources Department, working on this project on behalf of the town. Just want to, not a question, it's just a clarification, I hope. I am not here with any legal representation. I'm not here with KP Law. They're not on the call, and I don't have an opinion from them. That being said, if it would be useful, I could seek an opinion that could also be distributed to the Conservation Commission. Just not here with one today.
Um,
So just to point out that we're not lawyered up.
Thank you, Vince. Technically, as you know, a co-applicant or a joint applicant, there is legal representation from your side. You know, as SBPF does have legal counsel on the call. I think it probably would be wise of the town to as well have town council review in the same way that your partner, SBPF, is reviewing these documents. Because again, I think the more review, the safer we'll all be. And that's why Concom's independent counsel is so important here. Ian, I see your hand up.
Thank you, Madam Chair. So I mirror Mark Beal and Joe Klandowski's concerns. And for those who are watching this but haven't had the benefit of the letter from Hill Law dated December 12th, I'd like to read 2 paragraphs that are included for state and local regulations. The first, the state law, the General Law 40A, Section 16 reads, no appeal, application, or petition which has been unfavorably and finally acted upon by the permit granting authority shall be acted favorably upon within 2 years after the date of final unfavorable action. And then under our local regulations, Section 136 3F, no permit or waiver which has been unfavorably and finally acted upon by the commission shall again be eligible for consideration on a new application within 3 years after the date of final unfavorable action. So I do not have a law degree. I don't believe anyone on this commission, since Maureen Phillips was not reappointed, has a law degree. And I absolutely mirror Joe's concerns. And so I don't see how we can move forward. It's to even consider an NOI under these circumstances, for me, is putting the cart before the horse. And thank you.
Thank you, Ian. You know, I do agree. I think we will have a difficult time coming to a decision about the differing legal opinions here. So I don't know that we will come to a conclusion about the rehearing limit this evening. I do, however, think we could use this time wisely and at least have the applicant present their evidence or their reasoning that they have, you know, material changes in the circumstances, you know, that we essentially viewed unfavorably upon, to at least get those points on record. And if we have, again, kind of questions regarding those material changes or kind of differing of opinion, we can certainly discuss that. But again, it is difficult for me as well, to push through the differing legal opinions here in this situation. Seth?
Thank you, Madam Chair, and thank you for your last comment. With respect to my fellow commissioners, I think the provision on whether the rehearing limit applies or not is not particularly relevant, because it can be overcome by the fact that if there are specific material changes, the rehearing limit doesn't apply anyways. So as Mr. Golding said, none of us are lawyers. There's 2 separate legal opinions about the rehearing limit. I think we should focus our discussion on, as a commission, do we think there are material changes? And if there are any material changes, the rehearing limit is moot anyway. And if we find that there are not material changes, then we can end the meeting for tonight and seek a legal opinion on the rehearing limit. that would be my requested course of action, please. Thank you.
Thank you, Seth. Linda, I see your hand up.
I'm confused about the purpose of this meeting. I did call Jeff earlier today to find out exactly what we were supposed to be doing this evening. And it was my understanding we weren't going to have a hearing on the merits,
So
and then we're not going to talk about the details, and we're just simply sort of talking about whether we think we can rehear it or not rehear it, or how we want to arrive at that decision. Isn't that what this is limited to tonight?
it is. So we wouldn't describe the merits, but SBPF essentially has to present material changes from the permit that was just enforced upon. So they wouldn't present like sand values. We wouldn't discuss like why something would be more favorable than the other. We're literally comparing the last project to the new project, and the applicant has to, again, present the material changes. We have to discuss whether they, meet the threshold to rehear this. And then we would need to vote, ultimately in favor of rehearing or not in favor of rehearing before we would discuss the NOI in totality on its merits.
I'm also hearing, though, that several members would rather not make that decision as to whether we can rehear it or not rehear it tonight, based on the fact that we don't have council, our own council or town council weighing in on this at this time. We have the two opposing sides, but not anybody on the town side from a legal perspective. So I'm not sure where we're supposed to go from here.
No, I agree. It puts us in a little bit of a sticky spot. And that, again, is why I had hoped the select board would have given us counsel, but they didn't. The idea, and again, this meeting was scheduled kind of with the hopes that we would have counsel, and we don't. And in kind of in order to facilitate, I guess, progress, we can still discuss material changes, even if we don't ultimately make a decision on those tonight, and at least move this a little bit further forward versus just saying, nope, we're going to adjourn until next time. I would love to at least get the material changes out there on the table for discussion. And then we can see if we need, more advice from council or more information. Does that make sense?
It does. You've already heard my position on that. As to, I think we have an obligation to have to go hear it.
Yes, but as part of this rehearing, they need to, again, present why there are material changes to this application.
Their counsel is on here, correct? Not
Yeah.
just Murphy. Okay.
Yes. Matt Fee, do you have a question?
Or just, just a couple comments. First off, I thought we were gonna discuss it last night and it was not on our agenda. But we also, my understanding of whether you're going to have counsel, part of it was Jeff was gonna go back and we were gonna put some parameters upon it. I think the goal should be for the town and the Concom to be on the same page as much as possible for as long as possible. If we go direct, so maybe, that would be ideal. And so, as Vince said, why, town council could weigh in on this for the Concom if asked, but he's afraid of putting, I'm not afraid isn't the word, but he's hesitant to put something to you that is going to then be, I think, displayed as is tainted. We are not, SBPF's council is SBPF's council. They're not our council. Their engineers are their engineer. We have Arcadis as separate engineers on behalf of the town. That means the town as in you and me and all of us. We have counsel for the town on behalf of all of us. If in fact we are, get to the point where we are at odds, then okay, then maybe the special counsel. Maybe it can be, one idea that I actually spoke or texted back and forth with Ashley is maybe while we can right now, maybe it should be joint counsel right now until the point
So
where there is
Matt,
something that well, let me finish, please, Ashley. This is, maybe there's a point where we could have, where there's agreement, we don't need to be adversarial from the beginning. And then when we get to the point, we can say, okay, well, that is different. But so I think that's what my hope, to use Joe is talking about 2 cars driving down the road, we're gonna end up with 3 cars driving down the road.
So
So that's what I'm trying to avoid as long as possible. And unless there's some parameters put on it.
So thank you, Matt.
Thank you.
We sent a letter reply back to you guys outlining other reasons that we needed counsel after our last meeting 2 weeks ago. I don't know why it hasn't been on your agenda forwarded by your chair or the town manager. That is a mystery to me. Unfortunately, as far as our process is concerned, we have us, the commission, the regulatory body, and we have our applicant. You guys are joint applicants. So although you feel like SBPF has their counsel and you have your counsel, from the perspective of the application, you guys are working together. So if there's counsel opinion, that's, jointly from your side. And that is, I think, a point that kind of continues to get confused. And that's also a piece I don't want to go back and forth on during this meeting tonight, because we have requested counsel. We've gone there. We are trying to move forward productively in a non-adversarial way. And we had some simple requests for that. As far as I'm aware, every time we've heard Sconset Bluff before this, we've had legal representation, and I have asked Jeff to dig back and see how hard we had to ask for it previously when the town wasn't a co-applicant, because I think there's been a change in behavior here from the town side, which is a little bit unfortunate. And again, I don't want to come off as adversarial. I want to make sure that, the commission can make a solid justification on any decision, and that requires us to have counsel. Ian, I know I had seen your hand up. I want to make sure commissioners have their questions kind of out, and hopefully we can get something productive today. Ian, go ahead.
Thank you, Ashley. So I don't have much to add from what you've said, but unfortunately, Matt, you are a co-applicant, and so I would like independent counsel. I don't see how town council can advise both you as a co-applicant and the Concom. And we ordered the removal of the existing geotube. It was appealed, and SBPF lost in court. We sent you a letter saying we'd be happy to consider an extension, providing that a new application didn't include an extension of the geotubes and that the existing geotubes were modified. That was ignored by the town, apparently, because the town is the co-applicant on this new application. So I can come up with a lot of reasons why we need independent counsel. And that is a separate issue from us all hoping that this could be resolved amicably. Thank you, Madam Chair.
Thank you, Ian. Joe, I see your hand up. Oh, you're muted.
I support the position you're taking about the Baxter Road Group and the board, the select board. I've read these documents at least twice. It's pretty clear that the town and the Baxter Group are joined at the hip if you read those documents. And I don't see, it's not us, them, and another party, it's us and them. And the them are both of those joined together.
Thank you, Joe. And I don't want to overstep in your comment, but I just want to make sure that when you mean us and them, you just mean the regulatory body is separate from the applicant, and we can work together in that way, but we are separate entities and would have
Right.
separate counsel.
I agree. And yes, we can work together. I don't think there's any question about that. And we should work together. But the select board and the Baxter Road Group, that's separate from the commission based on these documents that I've been reading.
Thank you, Joe. Jeff, I want to go to you to see if you have any clarity.
I don't know if I'm gonna provide any clarity, but again, I just want to reiterate, right? Is whether the rehearing limit applies or does not. We still have to conduct the analysis of whether or not the application that was lawfully filed is substantively different enough to be heard regardless. So whether or not there's independent counsel that says, we believe the rehearing limit applies, you still have to conduct the same analysis at the end of the day to say, well, that can't be overcome. Or whether independent counsel comes and says, it doesn't apply, you have to hear the notice of intent. Is either way, we still have to go through it. So I was just trying to get to the, I would recommend instead of, I think we understand that there's a frustration about a lack of independent counsel, and I think that's well heard. That moving to discussing whether or not the application is substantially different than the previous project is a necessary part of the analysis, and I think is a good way to kind of move forward and try to make some progress to move past the frustrations already expressed.
Thank you, Jeff. And kind of another reminder, we can have this discussion, continue it in hopes that we would have independent counsel for the continuance and have whoever that counsel is, review this meeting and watch it to see if we missed anything, before we make any decision. So I'm hoping that makes sense to everybody. So at this point, I see Dwight Dunk, your hand up, and Dennis Murphy, your hand just went up. So Dwight, I want to make sure you get your question or comment out, and then Dennis, I'll go to you.
Yes, thank you, Madam Chair. Just you had, talked about, having the commissioners weigh in and then hearing from the applicants. I just wanted to make one brief comment and then hand it off. Number one, my brief comment is, Section F, permit and waiver rehearing limit, period. No permit or waiver which has been unfavorably and finally acted upon by the commission shall again be eligible for consideration on a new application within 3 years. Just the plain reading of that, a couple of comments. The most recent application that was acted upon by the Conservation Commission was for the notice of intent submitted in 2018, SE 483115. The most recent action in terms of the enforcement order was for the 950-foot geotubes that are currently installed, SE 482824. And now there's a new permit application submitted. I think the plain reading there can be deciphered. However, I would like to ask Gary Ronan to just describe a little bit his response to Mr. Murphy's letter. And then secondly, I would like if it's the chair would allow to have Ms. Lockmeyer describe the delta, the differences between the applications, the material differences between the projects as Mr. Carlson was mentioning, because that's the second part of the section. And if that's okay with you, Madam Chair, if Mr. Ronan can speak briefly and then followed by Ms. Lockmeyer. We felt it would be beneficial to have Arcadis, who's the town's consultant, provide those differences as a more, as someone who has not been involved with all three of these projects imminently. So I think having kind of a third-party perspective there to look at those differences.
Okay. I'm gonna go to Dennis Murphy before you turn it over to other members in your camp. Just in case he has a question or relevant comment. And I do see Joe Plandowski's hand up. Joe, do you have a question on what Mr. Dunk just stated?
Well, my concern is we should not try to get tangled up in the letter, those 2 letters from the attorneys. Forget that.
I know,
stuff.
but we don't need them right now, right?
The NOI.
Okay, so
Madam Chair,
Yeah, can
yeah,
everybody?
could everybody please be quiet? Because I didn't hear anything Joe said.
We need to mute everybody on the call. Thank you. Sorry about that, Joe.
I'll try that again. What we should do is forget the letters from the attorneys. Just put them in the waste can for right now and concentrate on the NOI.
Thank you. I somewhat agree having the attorneys go back and forth when we don't have our own representation. That's what we're waiting for our own counsel for. And we should be talking about the changes or the delta, as Mr. Dunk put it. But I do want to make sure Mr. Murphy can speak to his letter if he needs to. And then Seth, I see your hand up. Do you have a comment before Mr. Murphy goes?
Mr. Murphy can go. I've had my virtual hand up for quite a while. Can you see that?
Oh, it's blending in with your background. Now
All right, I'll change the color.
Yeah,
But he can go first. It's fine.
okay, sorry about that, Seth. 2 meetings in a row, not seeing you. Go ahead, Dennis.
Good evening, Madam Chair and members of the commission. I feel like I'm the one that started this, and I thought maybe I should try to streamline and clarify what I meant by the original letter that I submitted. I did not mean to suggest that the repetitive petition arises under the Wetlands Protection Act. DEP will never have anything to say about this. This only arises under your own bylaw. I also, I cited the state law, the 40A section 16, because when you hold them up one next to the other, it's clear whoever drafted your wetland bylaw used that as the model. There are whole phrases that are verbatim, identical, the same. I can tell you that these are your rules. You as the commission are the best people to interpret what you meant when you promulgated the rules, more so than me or Gary or even town council. In my view, it's a 2-part analysis. The first part is the applicability of the section. That's the more legal one. And I think you don't want to skip over that, because if it applies, it applies. The second one is the one I think that the chair and others were focused on. That's the factual determination, or what are the specific material changes? And when we get into that, I'll offer some. The one I highlight is on page 4 of the NOI itself, that says, quote, "The purpose of this project is to build upon the existing pilot project. The proposed project is a continuation of a long-standing effort." In my reading of the language of the NOI itself is that even the proponents recognize that these two are related. So I also, from the prior comments, I don't believe that you have to decide tonight. I don't think you have to take the vote. The one thing I would caution you is watch the clock and be mindful of the 21-day rule and extensions. And what you don't want to do is inadvertently waive whatever protections you might have. I think the commission is fine if it says, well, we're going to reserve judgment on whether the legal question of whether it applies. And while we're waiting for our own counsel, we'll make factual determinations about what the specific material changes are. The last point that I would make is that the person who, and it was town meeting that adopted this in 1999, by the way, but the person who wrote it didn't just copy and paste from state law. They made specific changes. So state law calls an application, and even Dr. Dunk just a moment ago used the word application. Your permit rehearing limit doesn't say application. It says no permit that has been unfavorably acted on. They want you to read it to say no application that has been denied. That's not what it says. It's broader than that. And in my view, it applies when you take and issue an enforcement order for removal that was just a year ago and upheld by the judge just a couple of months ago. And I come back to you and I want you to give me a permit to keep those same geotubes right there where you told me I had to take them out. That's the practical interpretation that this is repetitive. So with that, I'll yield and thank you for the chance to speak.
Thank you. Seth, I'll finally go to you. Sorry about that.
That's okay, Madam Chair. Can you see that color?
Yes, I can see that color.
So with respect to what everyone said, I don't think we're calling to skip over the discussion of applicability of the rehearing limit. I think, but there's no indication that any of those two provisions has to come first. They both have to be, acted upon, the factual side and the legal side. So it doesn't matter if we take the factual side first, which we as commissioners have the knowledge and the ability to do. I would say we have the ability to do that tonight. If other people disagree, that's fine. The legal side might take more time, but there's nothing prohibiting us from changing the order of, finding on those things. I would say, and maybe this is something I should ask Mr. Carlson beforehand, but I would say it is, again, important that the commission have counsel, whether that be, the general municipal council if there's not a conflict of interest, or an independent council if there is a conflict of interest. I know the town has been applicant on many notice of intent applications. And I was wondering if the Natural Resources Department could look into the history of those projects and see if there's ever been, any court cases where the town was an applicant and the Concom shared the same council. I doubt there was. Maybe there's not any court cases at all. But I think from a reasonable person's view of the situation, the role of the Concom is to be a regulatory permitting agency. If somebody is coming in with something that they clearly want permitted, that's why they submitted it, and they're having any type of support staff help them, whether that's technical support like engineers or legal support, those consultants are clearly advocating on behalf of the applicant. They're not advocating on behalf of the regulatory board. And although I agree with some of the comments from Mr. Fee saying that it would be great if the town and the Concom could get on the same side of it right now, or ultimately get on the same side of it. Right now, by definition, we are sort of on different sides, and that's not maybe an adversarial position. I don't want us to feel like we're at loggerheads, but the interests are separate, just given the nature of the logistics of the proceeding. So I would request that we look into the history of these cases, and I would request that the town and the select board, understand some of these concerns and grant counsel as necessary. But I think apart from that, we can talk about, the factual part of the material changes tonight without any counsel here, because we're more knowledgeable in that area than council would be anyways. Thank you.
Thank you, Seth, for putting so articulately what I tried to kind of spit out earlier. Sorry it took me so long to recognize you. Mike, I see your hand up.
Thank you, Madam Chair. I think everybody's had plenty to say about the legal counsel, and if we could possibly move along to getting on to the factual parts, we could make our night productive. Thank you.
Thank you, Mike. I think we're hopefully getting there. Mr. Ronan?
Yes, thank you, Madam Chair. I'm Gary Ronan at Goulston Stores. I'm the lawyer for SPPF. And I raised my hand now because I thought I would make a suggestion in terms of how to proceed tonight. I certainly am respectful of the commission's desire to have lawyers, although I would caution you against having too much faith in lawyers, knowing them as well as I do. But kidding aside, I think my suggestion is that perhaps Mr. Murphy, Dennis Murphy, and I could present the comments we'd like to present in terms of both what we've been calling the factual aspects of the material changes in the application, so that the commission has that to consider, but also provide some comments about what you've described as the legal aspects, so that if, as it was suggested earlier, what this hearing is continued after tonight, and then you have counsel who reviews the hearing, he or she would be able to have the benefit of those comments, and we wouldn't have to have a separate meeting again to provide our input on that. So I think if we do that, then you'd have essentially a complete record tonight. You could, after today, resolve the counsel issue, and then you'd be in a position to make a decision.
Thank you. I think hopefully that's what we will do this evening. So I know, Dwight, you had been up, and I asked for a few others to get their questions or comments out. Would you like to proceed with your group and presenting some of these changes?
Yes, I'd like to ask either Mr. Murphy or Ms. Lockmeyer to present the changes. As I said, I think maybe somewhat of a more third-party review there to present the differences between the projects that are under, the new project and the previous projects.
Okay, perfect. So I'm not sure who from your camp wants to jump in, but go ahead.
Yep. Jennifer, do you want to jump in?
I did, yes. Sorry, I just somehow lost my notes, and then I'll get started. First I would start with that it's been about a year ago since Arcadis was hired by the town to do an independent alternatives analysis, and it was for feasibility alternatives, long-term planning for Baxter Road. And as we looked at that, we came away with the safe alternative is to keep the geotubes in place until all other alternatives, such as road relocation, are ready to go. The extension of the geotubes is an effective solution that will stabilize the bluff for higher intensity storms. So that report has been available for about a year now. Both the NOI and the alternative access project were identified in the Baxter Road long-term planning documents that we finalized. And the expansion of the tow protection and development of alternative access were the adaptation pathways that we indicated to be protective of the area. They are considered effective and feasible. So we worked quite a bit with many different groups about it in terms of the adaptation pathways, as far as the timing and the solution preferences. And not all were completely in agreement, but there was somewhat of general agreement. So part of resilience is about redundancy and having backup plans and being flexible. So the erosion along Baxter Road does continue, but in the geotube areas, it is stabilized, and that has been continuously documented by the measurements that the town is taking.
Ms. Lockmeyer, I do want to make sure we don't get into too many details of the NOI, but really present the material changes from
Sure.
that we just acted upon.
Okay, so some of those material changes are the memorandum of understanding between the town and SBPF, the town's involvement and development and as a co-applicant on the NOI, and also the town's understanding and hearing as a result of the previous studies that there needs to be town oversight on O&M and reporting of this project. That was made very clear, and as such, a compliance plan and an O&M plan have been developed and submitted to the commission. Also, the town has successfully secured the monies for the removal costs. Those are in place. So other material differences is that the project, you know, it's not just about homeowners, it's really about a town embedded for the larger benefits of, you know, Nantucket as a whole. It's really about the consideration for maintaining the road, the historic sites, and the public benefits. These are the reasons that the town is a co-applicant, because they feel that there is a beneficial civic project overall. So the other material differences are that the current application, you know, has been modified now to really protect the north end of Baxter Road, because this is where we are seeing the greatest erosion and the greatest risk to the utilities in the town. The application also has greatly improved beach access and facilities for locations such as benches and bike racks and other amenities. Again, these were items that were heard from the group meetings, and so they have been included into the application at the request of the town. There's also there's also an offer to, you know, improve the access to the beach. That too was an area that was of great concern to the public. And so those are some of the material changes, as well as the compliance and the monitoring are very specific and very detailed and will be overseen by the town. Also, there's a lot more nature-based solutions, and these were identified in a different report, the CRP, and it would also, so it meets, again, the greater picture of what the whole town of Nantucket was saying that they want to see from these types of projects. So I think that's a summary of them, and I would just see if Vince wants to add anything there.
With your permission, Ashley?
Yep, go ahead,
Uh,
Vince.
Thanks. Jen did an excellent job covering all of that. The other thing just to catch is how the project would be structured, and that it's not as impactful as the current system. We'll be looking at up to 5 different selected areas that are termed in the NOI as reaches. Each reach has its own different way of progressing and being implemented, and to have different effects on the environment and to mitigate impacts. These more the southern reaches at reach 4 and reach 5 show this more. Reach 4, for the sake of argument, would start out just as Coir, and then there would be a trigger looking at bank slope conditions and any impacts there that over time and the failures of that bank before it would go to the next phase. And then in reach 5, that is almost all a nature-based solution for the most part, to monitor the current dune system there, then undertake dune nourishment as needed over time, and then once triggers come in place, and then later if the dune system were to ever be eroded away, that would trigger something else, such as core. But this would have set triggers over time and far more nature-based solutions and a lot more bank stabilization and plantings on the bluff face, and just looking at how we could, it was a major part for me to get more nature-based inclusion into this and to have set triggers and to try and define the triggers more, because that was something that we had some issues with for the previous application. And for this one now, they seem to be far more set.
Thank you, Vince. Mr. Ronan, I see your hand up. Do you have a question or comment?
Yes, I wanted to speak to this issue because I think it's important that we perhaps back up for just a moment. And when we're talking about the material changes, it's important to think about, or it's important to recognize what we're comparing. So I don't want to get too much in the weeds of the law, right? Because we're trying to stay away from that for now. But the context here is that the bylaw says that if it applies, and we'll set aside for now whether it applies, if it applies, you can still hear this application if you find there are specific and material changes. That's the language, specific and material changes, as between the project that was the subject of the prior negative action. So in this case, the enforcement, as compared to the project that's proposed in this application. So what we're comparing is the existing geotube project, which was permitted in 2015 and the permit was amended in 2018. We're comparing that project to what's proposed in this NOI. And just at a very basic level, I just want to make sure this didn't get lost in the somewhat more detailed points that you just heard. They're very different projects, right? The existing geotube project is a 947-foot long series of geotubes that are installed in the location where they're sitting there today. That's the project that was the subject of the enforcement action and the court's decision over the last couple of years. The project that's before you now in this new NOI covers more than 3,000 linear feet. So it's 3 times bigger. It includes geotubes in additional locations, but it includes other solutions as well. Some softer solutions, some dune nourishment, some coir, and other types of monitoring, etc. So just in terms of the geography, it's a very different project. And that's a very basic point. Another very basic point, and this was alluded to earlier by Ms. Williams, there's a different applicant. The prior project was SBPF. This is the town of Nantucket applying along with SBPF. It's a different project in that respect as well. And the only way, I guess I would say the only way in which the projects are not different is that it is true that the current proposal, the proposed project, would incorporate the existing geotubes. Okay, no question about that. And then the question becomes, does that make them the same project? Or are there still specific and material differences? Well, you've got one project that's 1,000 feet long comparing to another project that's 3,000 feet long and covers different areas, different solutions, all the rest of it. That's a very different project. And that's where we come to my baked potato example. For those of you who read my second letter that went in earlier this week, compare these 2 meals, right? You've got meal number 1 is a lobster, steamer clams, corn on the cob, a baked potato, and clam chowder. Okay, nice meal. Now I'm hungry. On the other hand, you've got a second meal. It's just a baked potato. Those 2 meals are very different. And the fact that both meals include the baked potato, the fact that the larger meal has one of its components is the baked potato, does not make them the same meal. They are very different. They are materially different. And that's really what the situation you have here. So I just don't want you to lose sight of those very basic facts about the very significant differences between the project that's being proposed now and the project that was the subject of the enforcement order. And so even if you were to decide, and for all the reasons we say in our letter, we don't think you should, but even if you were to decide that you think this bylaw can apply in these circumstances, in connection with considering whether there are specific material changes, you need to think about those differences in the projects, which you can do in addition to what's been said tonight. you can and should look at the application, right? You can look at the NOI, the new application. You can see the photographs in there, the diagrams, the descriptions of what the work is going to be, and you can compare that to the existing geotube structure, and you can see they're drastically different. And I wanted to make sure that sort of very basic points did not get lost in this discussion. Thank you.
Thank you. I actually appreciate that point because I really don't like baked potatoes and they can ruin a meal for me. And if you were like allergic to baked potatoes, let's say, and they're put on that second plate with all the other stuff, still ruins the other stuff because you're allergic to them. So, I mean, my question here, and when I read our permit and waiver rehearing limit, you know, the permit that was obviously acted upon unfavorably was that 947 feet. And you guys are proposing the same exact structure in that 947 feet with, you know, no change in height, none of that. So I do find that slightly problematic, and I don't, I almost see the extension as exacerbating what the reason we enforced upon and that removal. So, you know, I'd like to hear a little bit more about these substantial changes and have some of these other commissioners weigh in. But I really do, again, find it problematic that that same 947-foot structure is the same in this new application. And our ruling and the judge's ruling was that that be straight up removed. So again, that's problematic. Mark Beal, I saw your hand up, and then Seth, I'll go to you.
Yes, thank you, Ashley. My question is for our attorney, if we had one. I guess Mr. Rona maybe could help us, but I'm not sure. Well, let me ask the question. What do we do with the enforcement order? Do we just, if they do proceed, and now we have a 3,947 foot array of some kind or other, which includes the 947 feet, do we just ignore our enforcement order? Do we rescind the enforcement order? Or do we ask them to remove the geotubes and put nice new ones in their place?
So Mark, these are good questions. I know the enforcement issue is coming up on January 12th. It does certainly complicate the matter that we have the new NOI in before the enforcement issue, you know, fully played out, I guess. As far as process and to minimize confusion, I think it does add to the confusion, but they are separate. And that is something, I guess, individually we have to think about how that works. But essentially, I think if we were going to favorably permit an NOI with those 947 feet, it would somewhat make that enforcement moot. Yeah. Seth, your hand was up.
Thank you, Madam Chair. I'm going to try to walk a fine line here, so if I cross, tell me to stop. But I respectfully think the discussion of, you know, how does the 947 feet play in to the difference in the project? I don't think that's really a rehearing limit question personally. I think that's a merit question. So I think that, you know, there's a valid final court issued enforcement order saying that 947 foot project is not compliant, must be removed, and you know, is not meeting the protections of the Wetlands Protection Act. I think that if we got to a merit-based hearing of this NOI, the commission would find, based on the information, that the current proposal for the geotube in that area also can't meet the protections of the interests protected in the Wetlands Protection Act or the local regulations. But I don't think that prevents the application from being heard. I think there are other things in the application that, in my opinion, are noticeably different. I would say substantially and materially different. And we get applications in all the time. Sometimes we choose to permit only specific pieces of an application. Someone might submit an application and they're refusing to change their design. And we say, all these things can be permitted, but X is not permitted. So we can do that in the hearing with that section too. But I think that's really a merit-based question, not a hearing limit question. Thank you.
Thank you. Joe? Oh, you're muted.
In reading through the documents, the issue that just keeps jumping up to me is the issue of sand. For example, page 2, when sand source is secured, page 10, until sustainable sand source is identified. Page 50, sand source from off-island sand pits. This project's not going to work without any sand. And it seems to be an issue that.
Okay, I just want to make sure we don't go down the path of looking at the merits of the project and we're discussing material changes from the enforcement of the previous permit versus the new NOI.
I was just going to raise that point of order, Madam Chair.
I understand that. The reason that we're in the situation we're in now is because there was a lack of sand. And
oh boy,
in reading through this document, sand is a real important issue for this project. Thank you.
Thank you. Any other questions, comments from commissioners on the rehearing? I know we have Ian.
Thank you, Madam Chair. Attorney Ronan's comparison with lobster meals, apart from making us all hungry as around dinner time, I would argue that in fact, in a situation where both as served as separate meals, where both people end up with food poisoning because the lobster is bad, would make them remarkably similar. And to take that analogy one step further, the fact that the unmodified geotubes still exist in your new application are a similarity that I think some of my fellow commissioners have great reservations about. Thank you.
Thank you, Ian. Mike, I see your hand up.
Thank you, Madam Chair. I do agree with Seth. I see it as I see differences in the application. One, just from the applicant and co-applicant, good or bad, and with the structure of the project being 5 different areas with triggers, some of which the commission may end up opting not to talk about or act upon. Seems like a different application to me. And then I just want to go all the way back to a meeting we had, and it was within executive session, if I'm allowed to just point out one thing about that or no?
Just be careful. We can't share anything that was discussed in executive session.
Okay, well, I guess then the question is back to Jeff Carlson, just as basic as it was on the last SBPF application. What was the date for that? For that was heard. And Jeff might need to take some time to figure that out.
I can actually answer that if you would like.
Sure.
Go ahead.
The last application was filed in January 2018 and it was denied. This was the application for the expansion, was denied June 20th, 2019.
June 20th, 2019. Thank you.
That's correct.
Thank you. Any other questions from commissioners or comments before I move it over to representatives? Okay, looks like no. Dennis Murphy, you've had your hand up.
Yeah, just briefly, if you'll turn back to section 136 3F, I don't believe the comparison is between applications. It says specific and material changes in the circumstances upon which the previous unfavorable action was based. You're not being asked to compare one application to another. You're being asked what has changed since the circumstances of your unfavorable action. And I think Mr. Plandowski got at this, that the prior unfavorable action was a failure, a finding that failure criteria were met for lack of sand mitigation. And from my review of the NOI, and I will confess I've read every word, it has still the same 22 cubic yards per linear feet as the current order of conditions. It does not have the term adaptation pathway anywhere in it. It does not talk about relocation of Baxter Road anywhere in it. The citation to the MOU is the MOU from 2013, which was the exact same MOU as in the current OOC. And as I read to you earlier, it says right in the executive summary on page 4 that it's a continuation of a long-standing effort. It's the extension of the pilot project. Those are the applicant's own words in how they frame this for you. So I think that the focus should be on not comparing an application to another application. Your bylaw is broader than that. It's the change in circumstances, not the language of an application. And that's really relevant because we all know what's ahead of us if this hearing goes forward. It is months of competing experts and late nights, and nobody wants to do that unless you're convinced there's something different and we're not going to end up back in the same place. So I think that's the first issue. And, so far, I think that I certainly don't see it. And in terms of differences, everything that I've heard is not about a difference in the circumstances that resulted in your unfavorable action, your finding of failure criteria, your order of removal. What is it that has changed? If they came and said, we've identified an offshore sand source, and guess what? We're going to get the sand for free. That is a specific material change that is different from the current circumstances that precipitated your enforcement order. There's nothing like that in the NOI. Thank you.
Thank you, Mr. Murphy. Meredith Moldenhauer, you've had your hand up.
Thank you, Chairwoman. Meredith Moldenhauer, representative of the SBPF here. I just wanted to kind of, follow up on what our team had said and kind of maybe address some of the questions that the commissioners asked. I kind of, with listening to Arcadis and then Mr. Murphy, they outlined 13 different elements that are different here. And then I went through kind of with a little star and starred over 6 of those that specifically apply to the existing project and our changes. And then before I kind of walk through this, I want to start off by identifying kind of what Mr. Murphy just said. There are really substantial changes here in circumstances. This NOI is a collaborative effort, which is one of the 13 points of the town and SBPF. That change did occur in connection with the enforcement that your commission took. That was many conversations, discussions trying to improve and modify sections of the NOI based on the change in circumstance of this co-relationship with the town and SBPF in order to address issues that came up over the last number of years, and then obviously came to final conclusion in the action. So I do think that, just speaking on behalf of SBPF, and Mr. Murphy can elaborate on that, but our team does see a change in circumstance. And some of those changes just quickly include the change in the distance, the collaborative drafting of this NOI and of the circumstances around kind of preparing that, the checks and balances, new town oversight that specifically speaks both to the expanded project as well as the existing project, changing that circumstance, improving public recreation space, which would occur at the existing site as well as other areas, monitoring, which specifically relates to the enforcement questions, as well as improvements made by the town in order to monitor and enforce. The analysis that Arcadis did, that's a change in circumstance, that we were able to benefit from their independent analysis that we didn't have before, which was very helpful and provided feedback, input, and a lot of little things that maybe you are not aware of, but that went into the NOI as part of that. There are change in sand calculations and sand sourcing to the points that were made by commissioners tonight. As Mr. Murphy mentioned, change in the nature-based solutions and multiple combinations of methods, and then triggering improvements, which obviously do address the project as well as the existing project. So I hope that that just kind of helps maybe address some of the questions that I heard, and specifically point out, you know, the number of changes and the fact that some of those changes apply to the overall NOI, to the circumstances, and then to the existing project. Thank you.
Thank you. Rick Atherton, I see your hand up. You're muted.
I am. I just clicked. Ashley, I just clicked the button.
Okay.
Can you hear me now?
Yeah, we can hear you now.
You know, just a general comment on this. You know, why I think the issue of rehearing is important is that if we just take this out of the context of Baxter Road, and let's pretend we're hanging out in Mattocket, and someone comes in for a rehearing that you turn down and extends the width or the length of the application from 100 feet to 200 feet or 1 foot. You know, to me, that doesn't change the fact that that application didn't want to modify anything that had been approved. And I'm not sure I'm making my point, but once the issue here seems to me, the changes are easily applied in any such situation the conservation is faced with. And those are not substantial changes. The 1,000 feet that exists is not changing at all. I think that's the pertinent issue here. Thank you.
Thank you, Rick. Matt Fee, I see your hand up.
Yeah, just a quick comment. One thing I've heard a couple of times is sort of, it's as though the town is involved, you know, and is a co-applicant, and that's a good thing or maybe a bad thing. The town is involved as a co-applicant, and the reason that the town is doing that is to support the Concom. It's to strengthen and address some of the concerns that you guys had over a couple different years. So the intent was never, and it was always positive, and it wasn't the intent, and the town's increased you know, support for this, increased oversight is because of some of the shortcomings that you guys were seeing and writing us about, and admittedly we might not have been addressing as quickly at the time. And so I think that change of circumstance is substantial, and it's real. I mean, the town realizes that this is something that they have to be involved with and have to do a better job at. And that's what we're trying to do.
Thank you, Matt. RJ Turcott.
Thank you, Ashley. RJ Turcott again on behalf of the Nantucket Land Council. Just a couple points from the Land Council's perspective. At the end of the day, the commission is being asked to permit geotubes at the Toa-Sconset Bluff again. The phasing and the reaches are good for overall design, but they're essentially a foot in the door for the ultimate goal, which is the geotubes. And then two questions first is when we're looking at Arcadis's position in the long-term planning study, they did not recommend expansion. They said the current regulatory environment and the stakeholder engagement made it likely that this wasn't permittable. And none of their recommendations at the end of that document lead to expansion. And then a question, when was the appeal by SPPF of the Concom's decision on the 2018 NOI withdrawn? Because I recall that the commission jointly signed on and withdrew that appeal. So wondering when that action happened, because I don't know that that's a negative action, but it wasn't a positive action. I feel that the commission thought that they were in good legal position to win that. And the understanding was that it was withdrawn because we thought that Arcadis would help provide another answer. And lastly, going back to the Land Council letter that was submitted, this has been so fun already, but at the end of the day, these two boards, the Conservation Commission and the Select Board, really, really, really need to sit down and get on the same page together. Whether you agree with the Land Council's position on any of this stuff or not, the fact is that the town has an interest here to try to relocate that road. And there are a lot of things that are permittable and a lot of things that are possible, but these two boards can't keep functioning at odds with each other and exchanging through attorneys and letters written to each other. These two boards really need to sit down face to face and discuss what the ultimate goal is here and how the town can get there, because this is not how a good project comes out. This is not how it starts. So we hope that this commission will find a way to get on the same page as Select Board, because there's really no other option that will lead to a good outcome. Thank you.
Thank you, RJ. I believe that appeal was kind of dropped or settled out from under us September 2021. Jeff, am I correct on that?
I'll have to pull the exact date on that. I'm sorry, I don't have that off the top of my head.
Yeah, I'm pretty confident that's around where it was. Dwight Dunk, I see your hand up.
Yes, Madam Chair, just a couple of things. Listening to the discussion and going back to, Commissioner Engelborg made some very good points in terms of the differences in the applications and moving forward with the reviewing the application before you. Some of the discussion that has occurred since then has been regarding the technical merits of the current project and whatnot, which the purpose here is whether or not you can move forward with the hearing and then discuss those technical merits. So, I just want to mention that some of the discussion has kind of gone on beyond just, whether or not there is a material difference. And just one thing that I do want to point out, and maybe Ms. Lockmeyer, I know she had her hand, I was going to defer to her, but I just wanted to comment that the current application notice of intent references the Arcadis report, the Arcadis memo. It takes that into account, and this, as the notice of intent mentions, that also is a circumstance that has changed, where the town has looked at, engaged Arcadis to identify short, medium, and long term. And this is identified as a medium term action consistent with that alternatives analysis, so that the town can move forward with a long term action. And this is that medium term action to get to the long term. So, I mean, that's a different approach and different thinking about the overall project than previously. So with that, I'll just wanted to support what Commissioner Engelborg was saying and, concur with his thought process there.
Thank you, Mr. Dunk. I'm sorry if you feel we got into the merits. I thought we were doing a pretty good job about just discussing changes. And this is why it's helpful to have legal counsel and not just a regular hardworking person chairing after their job. And it's unfortunate that the town can't give us that so that we don't accidentally overstep somewhere. So at this point, commissioners, because Mr. Dunk, and again, maybe we have overstepped a little bit, let's discuss these changes. I don't necessarily feel comfortable bringing in extra information if they feel we're discussing the merits. So commissioners, I know Seth, you articulately stated your point. Mike, you stated that you felt there were substantial changes. I quite frankly am stuck on the 947 feet, our enforcement of that permit. And I don't see the circumstances changing there. I appreciate that the town is an applicant, but they're the property owner. I just don't know that I see it, quite honestly. Linda, go ahead.
I've dealt with these rehearings many times over the last 40 years, come March. And the underlying situation doesn't have to be removed or ignored or taken out. So the fact that the 900 is there in almost every single one I've dealt with over the years, the original thing was still present within the new application. There's no requirement for it to be removed from the application. So there's no requirement that 900 feet has to change or has to be removed and reapplied, et cetera, as you were going towards. So the material change is it's not at standalone 900 feet. It's got all the rest of the feet. It's got the different application, all the things that the SPPF brought up as changes. It does, as I say, it doesn't have to be removed or taken out of that equation. It just has to materially change by the addition of the extra feet, the linear feet, by the addition of the different applicant, et cetera, et cetera, et cetera. So I wouldn't necessarily get too hung up on the fact that the original 900 is still in there, but it is not a standalone application, and that's where the material change applies. So none of the ones I've dealt with before had the original thing not there, still somewhere in the mix, but it had changed overall.
And thank you, Linda. I totally see your perspective. I think my perspective on the 947 feet and the expansion, although different, I think it exacerbates the circumstances under which we made the last decision. So that's where I fall. And I respect commissioners with differing opinions here. This is a very tough discussion that we're having. Ian?
Thank you, Ashley. So I really agree with what you've said. And in reading the section of 136-3F again, where it says specific and material changes in the circumstances upon which the previous unfavorable action was based, I don't really see the circumstances as having changed. So the existing 947-foot array is a terrible design. It doesn't put nearly enough sand into the littoral system during storms.
Just be careful that we don't discuss merits and we
Okay.
discuss just changes.
Sorry, I beg your pardon. So the circumstances, I would say, we're being asked to trust an applicant again to provide the sand that they haven't done before. And I could go on, but I just would say that the circumstances have not changed. And so that's my opinion on this subject. Thank you.
Thank you, Ian. Jeff, I see your hand up.
Yeah, I just wanted to add in, and I know this may be a kind of a common sense moment for everybody. But I did wanted to say that if you feel that it's different and it doesn't apply and you guys make that determination and allow it to be heard, by no means does allowing it to be heard do anything to affect what the decision that you guys can make at the end is, right? I just want to clear that up for you guys and for the public, that it can still be heard and judged on its merits and be issued a positive or negative order of conditions based on those merits at the end. That deciding to hear it doesn't predispose that decision. So I just wanted to put that out for everybody too, since we're kind of kicking that around.
Thank you, Jeff. Joe, I see your hand up. You're muted.
Yes. If it'll make you feel better, I'm just looking at the new way this is put together. There is no 947 feet. These reaches have numbers that are far different from 947. And I don't specifically understand where the breakpoints come in there.
Thank you.
May I, Madam Chair, through you to Joe?
Yeah.
I was just referring to the original 3 and 4 tier array, Joe.
Okay.
Thank you, Madam Chair.
Thank you. Linda, I just want to make sure your hand's not back up and it's still up from the last time.
I had one more comment there. Is this the point where we don't make a decision because we don't have town council's opinion? Is this the point where we go ahead and continue this discussion to the January 12th meeting? And hopefully we'll have an opinion from town council at that point, and then we make the decision as to whether we can hear it or not. Because we were floundering around at one point about the lack of town council opinion.
No, I think we're right about there, Linda. I just want to make sure all commissioners get out their thoughts about the hearing limit, whether we've met the merits or not, and then we could potentially continue. And I see a bunch of hands going up. Ian, I see you, and I saw Seth, and then I see you, Mark.
Thank you, Ashley. So I have no interest in town council's opinion at this juncture because of what we've discussed before. I want an opinion from a council that represents us alone. I say that with the utmost respect for town council and the advice he's given us in the past. Thank you.
Thank you, Ian. Seth?
Thank you, Madam Chair. Just one point to put out there. I think has been decided on by this board before that simply changing an applicant is not considered a specific and material change. You know, that provision is so that somebody doesn't submit a notice of intent and it gets denied, and then they just let their neighbor submit it, or they let their renter submit it, or whatever. So I although there are different applicants, I don't think that's a specific and material change in circumstances. I personally think there are some other ones, but I don't think that is a specific and material change. But I don't think we need to find that every change is specific and material. We just, I think the reading is we need to find that there's at least one specific and material change. And if we had counsel to correct me, I would appreciate that. But that's how I read the provision. If there's at least one specific and material change, then we should hear it.
Thank you, Seth. Mark, your hand had been up, and then Ian, I'll go back to you.
Yes, thank you, Ashley. I have a question regarding the it's not the actual project, but it's what's involved in the project for a change, and that is, are we approving just the 5 reaches as they stand, and will the applicant come back to get a permit for changing from the dune field to quar rolls and the quar rolls to geotubes? Are we in a sense, in effect, permitting ultimately, if need be, geotubes for the entire 3,000 plus feet?
Looks like Jeff can take that one.
All right, So Mark, I think to answer that question is typically past practice of the commission when dealing with phased projects and triggers is you can certainly discuss how those triggers activate, but I think it's always been our recommendation in practice to include some provision to be back in front of the commission to activate those triggers and to condition that through the order. I think we've seen it, everything as simple as, you know, coming back in after invasive species work to say, hey, we need to do some supplemental plantings now. We need to do that, but to bring that back in front of the commission, I think it's always incumbent upon the commission to, you know, fuel decisions based upon, you know, actual real-time data for what's going on and actual information at the time. And to permit an activity, you know, 3 years in advance to some level of specificity is probably impossible, especially in a dynamic system like this, where I think, you know, putting that condition to say, we agree with the concept of phasing on a project, but to activate the phases, you need to come back and have a discussion about making sure that it was properly triggered and go through that would be entirely appropriate.
Can I follow up, Ashley?
I'll say yes, because it looks like she froze.
Oh, okay.
Oh, sorry, I was muted.
Well, Jeff, this application had those 5 reaches, which all expressed possibility of expansion. I don't recall there was a note in the NOI to come back for us to permit the changes. It was going to be a carte blanche application, carte blanche permit. And I kind of like, we can change that, I realize, and we've done it in the past, I know. But the application, I think, was for the entire bluff to be potentially geotubed.
No, I understand that. I would say that those are the perfect situations for why we do orders of conditions. So you could condition that to make sure that appropriate action was being taken place at the appropriate time. Even if the request is for something different.
Thank you, Jeff and Mark. So I was muted that last time. Ian, your hand had been up, and then Mike, I'll go to you.
Yes, thank you, Ashley. And I certainly don't want to beat the subject to death, but when Seth was talking about specific and material changes, the way I read that sentence is it says specific and material changes in the circumstances, which is very different from focusing just on material changes, which is why I made the point earlier on that the circumstances hadn't changed. Thank you.
Thank you, Ian. Mike?
Thank you, Madam Chair. As usual, Commissioner Beal brings up some good points. If we do elect to go on in here, my expectation would be that we would have to discuss each different area phase and see what we thought if the commission as a group thought they should be included. Thank you.
Thank you. So I do think we're probably getting close-ish to continuing this unless somebody had a motion they wanted to make. But I do want to let Ms. Lackmeyer and Mr. Ronan speak. You've had your hands up for a while.
Thank you, Chairman Arisman.
Oh, we lost your sound.
I'm muted? Okay.
Now we can hear you.
You can hear, sorry. Thank you, Chairman. I wanted to say, as a civil engineer who has been working with the town and studying the utilities and the imminent, failure that could occur to Baxter Road and the utilities in Baxter Road, what I really worry about is the actual impacts to the sensitive resource areas, to the beach, to everything in the event of failure. So I think from that perspective, I'm wondering if there is another way to help all of you who are working so hard to protect all the town resources and kind of, I guess, going from where what Mr. Turcott had said. I'm wondering if there's an opportunity to bring the two boards together and have more of a technical discussion. You know, as I think about removing any kind of system that could afford further protection, it really concerns me for the town, for the utilities, for the sensitive receptors. So I was wondering, with that in mind, if there's sort of a different path to allow more conversation between the select board and the Conservation Commission, just purely based on just technical engineering, scientific matters. No lawyers.
I mean, I think if the select board wanted to meet with us, they could make that request for a meeting. You know, right now we just have what's before us, which is a notice of intent and then an enforcement issue that we're dealing with. But certainly if the select board wants to participate a little more, I know we have Matt on this call, and Matt, I do appreciate your consistent participation through this matter. You really, again, have been kind of steadfast in paying attention and being up to date. I worry that some of maybe the other select board members aren't as familiar and could maybe use a joint session with us. But again, that request could hopefully come from you guys at this point, as we have a notice of intent in front of us that we need to hear and deal with enforcement issues. But thank you for that suggestion. Seth, I see your hand up.
Thank you, Madam Chair. And in response to Ms. Lockmeyer's and Mr. Turcott's suggestions, I am personally, 100% in favor of meeting with the select board. I'm not a civil engineer, but I'm an ecologist, and I have a broad understanding of the types of solutions that have been used across the country for dealing with coastal resilience. I would say, however, though, the way the process is designed for the Concom is, we hear applications that are submitted to it, and we base them on the merits of each application. We as a Concom, each one of our 7 members probably has a different opinion about, in an ideal environment, hypothetical, what should be done in this area. I have a vision for a great alternative to this project that I think would protect everyone's interests and be much more environmentally friendly. But I've never shared that with anybody because it's outside the scope of our review. There are plenty of, and if I'm getting into the merits, stop me, but there are plenty of alternatives to the proposed interventions here. There are many more nature-based solutions, many more types of living shorelines, many more types of soft engineering structures that aren't considered in this project. We have an alternatives analysis that very, very briefly talks about why they weren't considered, a couple pages out of 300 pages. I view that as inadequate. I would love to sit down with the select board and the town staff and say, this is what I think should be done. But I recognize I'm just one person, and I don't speak for all 7 members of the Conservation Commission. That's why our process is to review things as they come in. So I think if we're going to do that, we need to have a meeting with the Concom just independently itself to talk about what we think, and then we can bring that to the select board, because I think each one of us has different views about an ideal hypothetical solution to, this area of the island. Thank you.
Thank you. I don't want to get too far off track with this meeting with the select board now, although I appreciate that it's part of this. I'd like to kind of tie up one and then maybe move to the other. It is, again, unfortunate. I think we tried to speak with the select board, have them hold off on their MOU a little bit. Like, there were all of these opportunities, and again, maybe we weren't being heard the way we were trying to be heard at that period in time, which is too bad. But I don't want to muddy the waters of the current NOI in front of us. So Seth, I do agree with you there. It could get a little bit dicey with an application in front of us. Mr. Ronan, you've had your hand up. And Matt, then I'll go to you.
Thank you. Thank you, Madam Chair. I just want to make one point very clearly. It's been touched on a couple times, but for those members of the commission who maybe haven't focused on it, the issue that we're talking about here is not whether this project is a good project. Ultimately, it's not whether you're going to ultimately allow this project. It's simply whether you're going to hear what we have to say about this project and why we think it's a good project. And I don't want it to be lost that I recognize that there are a number of commissioners as well as members of the public who have very strong feelings about geotubes in this location, and the way the project has been managed in the past. What we're really trying to do is ask people to keep to whatever their feelings are about the past, to look toward what the future can be, and as part of that, I don't want it to be lost that a number of people worked really long and really hard on this notice of intent. As town staff, including Mr. Murphy, including Mr. Fee and other members of the Board of Selectmen, including the town manager, Ms. Gibson, including professionals at Arcadis and Epsilon and other places, have worked really hard. And the reason why they've done that is they believe, and I do too, that this project is a good project, that it's in the best interests of the people who live along Baxter Road, but also in the best interests of the town of Nantucket as a whole. And then it can save, at least for a period of time, Baxter Road and access to the lighthouse. And all we're asking for on this piece of this whole big puzzle, right, on this piece, this bylaw, is please listen to what we have to say. That's all we're asking for right now. And you don't have to decide tonight or in the continued portion of this hearing whether you agree, whether you think the project complies with the law, any of that. All we're looking for is for you to say, yes, we will hear the application, we will listen to the merits, we will hear what you have to present in terms of the project, and to see whether we can persuade you that it or portions of it, to pick up on some comments that have been made, are projects that comply with the Wetlands Protection Act, your local bylaw, and the regulations, which of course is what your duty is to do. And I just want to make sure we're not losing sight of that is the task for tonight. Thank you.
Thank you, Mr. Ronan. I don't think I lost sight of it, but there's definitely people interjecting new ideas in here as we go. Joe, you had your hand up for a while. I do want to make sure to get to Matt Fee, and I see Ian, your hand up. And then commissioners, we've got to decide whether to continue the rehearing conversation or make a motion now. Because I don't want to go further into NOI discussion, et cetera, that could get us in trouble. So Joe, go ahead.
Ashley, I wonder how different a review of this NOI would be if we could erase the last 3 or 4 years. And I wasn't here for that time period, so I can't answer that question.
Yeah, I mean, it's a good question. I think probably it would have been great if there could have been a delay on the NOI so we could have solved the enforcement issue. Having them go concurrently, maybe wasn't the best choice, because then you're literally hearing issues from the last 3 years at the same time as you're hearing this new one.
Yes.
But yeah, I mean, we as a commission hear each notice of intent on its own merits, on its own legs. So I trust that, commissioners will have the ability to do that.
Thank you.
Thank you. Ian?
Thank you, Ashley. So, Mr. Ronan, I absolutely take your point about how much work has been done. And I just want to show you here. This is how much work as a commissioner. These are my notes on SBPF. So there's been an awful lot of work on this from a lot of parties.
Thank you, Ian. Matt, your hand's been up for a while.
Yeah, just a quick comment. I think my understanding is when we've asked previously to meet, it hasn't been an application in front of you, so you've been hesitant. I would, I think, I sort of heard Seth say it'd be a good idea to meet, but maybe if it's in front of you, it's not, which is kind of the same. I think, as you guys know, I'm willing to talk to any of you or talk to anyone about it. I would like us to meet. I think getting face to face and, and putting all your cards on the table and having honest conversations of the future is important. I think that that's something we could do, but it should not slow this process up. I think, it would be great if the NOI was going separately with enforcement, but the enforcement went last February and didn't get heard. And the maintenance and operation didn't really get heard. So I think it's all happening. And I think Joe hit it on the head when he said, would it be different if things had gone differently? And it would, but we are where we are, And so I think what I'm trying to do is to sort of move forward positively and make choices that allow us, as boards to come together as much as possible, hopefully a lot, and have the long range good of the island in mind. And, so I think that's, so I will ask, I will go to the select board. I'll ask if they'd like to send a letter and have that conversation, but I hope that doesn't cause this all to slow down, because this is important as well. So thank you.
Thank you, Matt. I must admit, what's slowing us down is not having independent counsel. So if you could plug that one, it would be really, really, really helpful.
You've done a pretty good job of that yourself today, Ashley, I'm going to say.
Yeah. So hands are going up everywhere. Mark, I see you, and then Seth, I'll go to you, and then Linda, you are next.
Thank you, Ashley. I'll be very brief. I think a sit down with the Board of Selectmen face to face, no attorneys, would be very helpful.
Thank you,
The
Mark.
end.
Seth?
Thank you, Madam Chair. I think we're at the point of today's discussion where no more substantive information is probably going to be entered into this record. I think I'd like to focus on the logistics of moving forward. So, there's been some talk about continuing this discussion. I'm not sure we can actually do that with our 21-day hearing limit unless the applicant agrees to that. So we want to make sure we're not, failing to hear the notice of intent in a timely manner. I think we should ask the applicant if they're willing to do that. And then if not, I would, get right back to making our decision on the rehearing. Thank you.
Thank you, Seth. I agree. I think we're getting to that point. Linda, do you have a question or comment? I see your hand.
Well, I think meeting with the selectmen, we've advocated for that for a while as a group. We now have an issue of perhaps we have get into an ex parte communication because they have made an application. It's in before us. And I don't think we can meet outside of having our regular hearing on this application. If we want to have the meeting in that environment, that's fine. But having a meeting with no attorneys, no this, no that, that's going to be problematic because they have made a formal application to us. So if we're going to have the joint meeting, then we have to do it within our regular hearing process on a notice.
Thank you, Linda. I was actually going to say I wanted a council opinion on what we could discuss. So it sounds like you have the similar concerns.
I think it's great, but we got to do it within our normal hearing process.
Yes. So
since they're an applicant, they can come in all together and post it for themselves.
Right. So maybe it can be posted as a discussion or something. It looks like Jeff might have some suggestions.
Yeah, I mean, you guys can certainly schedule a hearing day. I mean, you have an open application in front of you right now. You can simply post the meeting for a discussion on the application. I mean, they're an applicant here, and the 5 of them can come and you guys can discuss whatever you want related to the application. I mean, the select board has posting requirements as well that they would have to meet and call a meeting to order, but it's certainly possible to do. And review those things and even talk about things in a little broader context if you wanted to. I don't think that that's overwhelming hurdle to overcome to have a joint meeting to discuss how to move forward collectively on this.
Thank you, Jeff.
Can I have one more thing really quickly?
Yeah.
Sorry. And I would say too, if it's something too where obviously, Vince is here, not to be lost in the madness, the town managers is here. I know that our staff and town staff hear from you guys and hear from the select board and all those things. I'm sure there are consistent items that, we might be able to help assemble that have been discussed and create kind of an accessory topic list that go with it, that I think we could probably do and circulate, that kind of helps and jogs people's memory for what's there, or can just leave it to, the 12 of you guys to discuss too. I think that's certainly possible. But from a staff level, I think we're willing to help facilitate whatever conversation moves us all forward in a positive way as best we can.
Thank you, Jeff. We're very lucky to have you guys in the Natural Resource Office trying to coordinate all this and get everybody on the same page. So I appreciate that. So at this point, I haven't heard a motion from any commissioners, which makes me feel like we're waiting on a legal opinion to further discuss this. So I'm wondering if a representative for the applicant would be willing to request a continuance.
An extension of their 21 days.
Well,
It would be a continuance of the hearing, I believe, to a date certain, and then the 21 days would start from that next date certain. Mr. Dunk, go ahead.
yes, Madam Chair and Commission members, my notes show that when at the December 1 meeting, just for clarification to Commissioner Williams, that the commission did vote to open the public hearing because that was day 20 after submission of the notice of intent, and it was continued to tonight for the discussion regarding the rehearing of a permit. And then it was also continued to January 12th. At that time, it was the intent was that this would be addressed tonight. This topic will be addressed tonight, and then a technical meeting, public hearing on the technical merits to be opened on January 12th. So with that preface, we would assent to a continuance to January 12th.
Okay.
I do remember that discussion. Yeah.
Yeah. Kind of the
Do you
double.
need a motion from me to continue to January 12th or?
We don't need a motion. We can accept the continuance. So thank you, everybody, for participating. I know this is a complicated subject. Some people have already formed opinions, and it can be difficult. Jeff, I see your hand up.
Sorry, I didn't want to interrupt your closing remarks, but I just wanted to make sure I had our instructions clear. Obviously, there were some questions raised for information for us tonight, but just wanted to make sure everyone was okay if we're contacted by the select board to start trying to either look for if it's the 12th, it's the 12th, or alternative dates to have that joint discussion if that's something they're interested in. That we can work with you guys to schedule that. Just want to make sure everyone is okay going through that exercise.
Yes, I would like, I guess, town council opinion. Council needs to weigh in on that, just because I think it could be problematic with the current application.
Okay, well, we'll get all that together and get that to everybody, but I just want to make sure that we were good proceeding down that path. If it sounds like this board is interested in doing that, as long as the select board is also, and Matt indicated that he was, so hopefully that can positively move forward and we can work to schedule that as well.
Thank you, Jeff. Ian, I see your hand up.
Thank you, Ashley. Can we make sure that the subject of independent counsel is on the select board's docket for the next select board meeting?
I think that's a good idea, Ian, and it might also be worth resending the initial letter that we sent about extending the enforcement, because that clearly laid out that for us to extend the enforcement or removal deadlines, that we would need counsel for this. Maybe that piece as a little reminder might also be helpful. But I agree, thank you. So we have agreed, or the applicant has agreed to continue this until January 12th. So at this point, we'll end the discussion on Sconset Bluff. We don't have any orders of conditions because we didn't close. Does anybody have any organizational questions they want to ask? I know Ian, you just asked one, but anything before we hopefully have a motion to adjourn? Looks like no. So does somebody want to make a motion to adjourn again?
Yes, I move to adjourn, and I also wish everybody happy holidays and a very Merry Christmas if they celebrate Christmas. Thank you, Ashley.
Thank you, Mark. are you-
Second.
Second, all right.
I second that, Ashley, and I'll congratulate you on running a very trying meeting. Well done.
Oh, thank you.
Exactly.
Same here.
All right, guys, we got to roll vote this. So Beal,
Aye.
Engelborg,
Aye.
Harrisman, I, Golding,
Aye.
Mizzarelli,
Aye.
Landowski. Oh, you're muted.
Aye.
Williams.
Aye.
All right, this meeting is adjourned. And again,